Good morning. Today is January 16, 2025. It is approximately 9:30 a.m. This is the matter of application Z0436-23. This is an application that was approved by Planning Director decision and has been appealed. The appellants in this matter are Stafford CPO. Present on behalf of Stafford CPO is Randall Yamada. The second appellate is Stafford Investments. Present is Robert Follow on behalf of Stafford Investments and his attorney, Jesse Burgess. Present on behalf of the applicant is Mark Huchet. Excuse me on pronunciation. Is it Huchel? Huchet. Uh, and his attorney, Wendy Kellington. Present on behalf of Clackamas County is Planning Joy Fields. My name is Carl Cox. I'm Clackamas County Land Use Hearings Officer with authority to conduct this hearing and make a determination in this matter. I will state several important things for the record this morning. First, I've not received any ex parte contact, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I have reviewed the exhibits that were submitted in advance of this hearing, including the original application, the county's decision approving that application, the appeals, and a number of other exhibits, including some exhibits that I've only had an opportunity to skim as they came in late, and that included a substantial memorandum submitted by Mr. Burgess. So I haven't had an opportunity to review it in detail. However, I will. I've considered issues of bias and conflict of interest in this matter and have determined that I do not have any bias or conflict of interest. The county is making a record, and at this time, actually, at this time, I'm going to make a statement that I have already received a request to keep the record open. We'll discuss that prior to closing this hearing. At this time, I will ask that the county provide an explanation concerning participation in this hearing via the Zoom platform. Go ahead.
One moment, let me bring it up.
Sure.
This is a public hearing and will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, the applicant, and the appellants, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. When you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar, which is located at the top or the bottom of your screen, depending on the device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all of the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to have your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email the written testimony to myself, Joy Fields. My email address is jfields@clackamas.us. Or you may mail it through the mail to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact and email address is also available on the webpage where you found the Zoom link for today's meeting. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify, but you would like to receive a copy of the decision, you must provide your email or standard mailing address by emailing it to the staff contact for the application or by entering it in the Zoom chat function during the hearing.
Thank you. This is an appeal of a previously approved staff decision under type 2 procedure. This is the appeal authority is the county's land use hearings officer, and I will review the application and the testimony and exhibits that are submitted against the approval criteria. My decision will be de novo, so I'll be making a decision based upon my review of the application, considering the information also submitted and testimony submitted by the appellants in this matter and public comments. The order of proceedings will be that I will ask that the county begin by presenting the county's staff report concerning the decision that was made in this matter, followed by an opportunity for the applicant to submit additional information in support of approval of their application, followed by an opportunity by each of the appellants to submit information about why this application should not be approved. I will also certainly provide an opportunity for members of the public to make comments either in support of or in opposition to approval of this application, or just general comments as well. I may provide a rebuttal period. Prior to closing the record in this matter, I will provide an opportunity to discuss keeping the record open. As I stated at the outset, there is a request to keep the record open following the conclusion of this hearing to submit additional information. I may consider a request to continue this hearing to another date as well. We will determine we'll see what happens during this hearing this morning so that I can be better informed as to whether that would be required. At this time, I'm going to ask Ms. Fields to begin by presenting the staff report and any presentation that she has.
As the hearings officer stated, staff reviewed a land use application for a modification of a conditional use for Rolling Hills Church to add a parochial school to previous land use decisions. The file number is Z0436-23. The previous land use decisions that approved the construction of the church building at the size that it currently exists were Z0351-02 and Z0160-09. The applicant proposed a phased approach for opening the school use. They originally wanted to start with daycare and move into a K through 5 school. After the transportation study and analysis, the applicant decided to change to just having the final K through 5 school use with 150 students maximum, and understands that additional students and additional school providing would require additional transportation impact analysis. The application was approved with conditions. The original impact of the proposed use does not increase the square footage of the building. It does not require additional parking. It removes no landscaped area or open space. And the applicant provided evidence that the participation in the church in the mid 2000s was at a significantly higher number than there is today. In the 2002 land use application, you will see that adults and children used the school Tuesday through Sunday, and there was about 1,500 people that used it through that time period for the classroom and for the learning opportunities provided during the week by the church. The subject property includes many different parcels along Southwest Borland Road. There are lots of different tax lots that are combined for this project. They include tax lots that have single-family dwellings. They include sports fields and the existing church and parking lot. As I noted, there are 2 previous land use applications. The original application filed in 2000 or approved in 2002 was to allow an increase in the church that was approximated to be a 400% increase that would allow an auditorium and capacity of the church to increase significantly to provide the services to the community. The underlying zoning district is zoned rural residential farm and forest, 5-acre minimum, and the school use is identified as a conditional use subject to 805. However, with the previous land use decision in 2002 that identified it as including a school use as an accessory use to the church, this application was reviewed as a modification and is subject to 1309. And that is a process that is allowed in our zoning code when there is an approved type 2 or type 3 land use application. You can submit a modification as long as you meet the criteria in 1309. One of the items is that the modification shall be consistent with the prior approval. Staff found that with the church footprint not increasing, with no change to the access, and with the use being identified in the original application, that it was consistent with the prior approval and was just a modification of that approval. The modification is supposed to be consistent with all of the ordinance provisions in effect when the modification application was submitted. And so staff reviewed the development standards in 1000 and made findings to those that were applicable for this application. A modification of a previous type 2 or 3 land use application is not supposed to significantly change the type of use. In our code, industrial uses and institutional uses are defined. And when you look at the definition of an institutional use, places of worship and schools are both considered institutional uses. And so changing the use of the structure to include school use was found to be in the same type of use. As I mentioned, there's no increase to the overall building floor area, and so there's not the 25% increase is met, and the original lot coverage that was approved was not changing. The modification is not supposed to result in an increase in the density of development, an increase in traffic congestion or public facilities, a reduction in approved open space, a reduction of off-street parking or loading berths, and no reduction to the required pavement width or access is allowed for it to be considered as a modification. If these things were found to not be met, then a conditional use would have been required for the proposed change of the use of the building. The traffic impact analysis provided by the applicant concluded that the impacts from the proposed 150 students for the K through 5 school would have minimal impact to the transportation facilities, and that the new site trips were not expected to significantly alter the operation, safety, or capacity of the existing transportation facilities. In table 130701, land use permit procedures are identified and the pathway to land use approvals are clearly shown. And the piece that applies to this modification application is identified here on the screen, showing that a modification of a previously approved type 2 or type 3 land use application is a type 2 procedure. And therefore, it didn't require another public hearing unless appealed. And that's why we are here today with the public hearing, because it was appealed. Staff found that the zoning and development ordinance criteria were met and had conditions placed on the approval to ensure that the evidence that staff relied on to find that the criteria were met are maintained. If you would like a copy of the HO decision or would like to provide additional testimony, you can send that to myself, as mentioned in the earlier introduction. My email is jfields@clackamas.us, or you can mail it to our office. With that, I will end my staff decision summary.
Will you add your presentation as an exhibit?
Absolutely.
Perfect, thank you. At this time, I'm going to provide an opportunity for the applicant to provide additional comments, testimony, evidence in support of the application.
Good morning. My name is Don Carter. I'm a board member at Rolling Hills Community Church and have attended there for 35 years. And we believe as a church that in following Jesus, we are to reach out to those who are hungry, those who are sick, those who need clothing. We need to take care of children, especially. And we believe that using the church facility for the benefit of the community is an important part of what it means to follow Jesus. In that light, we've have a relationship with the Tualatin Food Pantry in our building, serve several thousand people a year. We have a free medical clinic there called Borland Free Clinic. Northwest Children's Outreach is located there, Kids Around the World, and a clothing dispensary, among other things. As we talked with community members and members of our church, the need for high quality Christian education arose. We have talked with other churches in the area that support schools, including Horizon, and many of them need additional space or have waiting lists that indicate the need for this in the community, which we think is rising. Here with me today are Mark Couchet, who is the executive pastor of Rolling Hills Community Church, our legal counsel, Wendy Kellington of Kellington Law Group, and we also have Jennifer Wendy from our transportation engineer, Lancaster Mobley. I'm going to turn it over to Mark Couchet at this point.
Thank you, sir. I apologize for my mispronunciation earlier, Mr. Couchet. Please proceed.
No problem. I get that all the time. My name is Mark Couchet, and as Don said, I'm the executive pastor at Rolling Hills Community Church. And I'm also a staff elder and the secretary treasurer of the organization. I currently oversee all staff, ministries, business, and financial operations of the church. In 2023, we began to hear a consensus from our growing young families for the need for Christian education options for their children. Many of these parents expressed concerns for the current wait lists or that some schools were already at maximum capacity. At the same time, independently, we were approached by 3 different schools, each with proposals for them to use our facility to expand their current existing Christian schools. 2 of them are currently in the local area, the Stafford Farm School and the Bethlehem Preschool. With all of that feedback, we began to feel the call that this is an area for us to step into based off of what we were hearing from our members, but also potential partners who were approaching us. So our first stop in this process was the county to begin the process of what we needed to move forward. During that time, we began to work with Joy Fields and her term, which were outstanding in their guidance and answering of our questions. We began the application process and actually completed the application and had scheduled a pre-conference with the county staff with regards to our application. At that time, after seeing our completed application, the county felt that we may meet the requirements of 1309 if we agreed that we met all those requirements, which we did. So we chose to withdraw the pre-application conference and submit as a modification application. The county felt because the child care school is an institutional use and the church is an institutional use per 202, that we may be able to do a modification of a previous conditional use application. We felt that we met those requirements and followed the suggestion. During this process, we evaluated many things for their application, our current water usage, which we felt with the addition of the school, that we would still be well below the daily allowable use. We also secured the services of Lancaster Mobley to do an updated traffic study for this request. And I believe there's a representative here today from Lancaster Mobley that will be able to answer any questions. Rolling Hills has always tried to be a good steward regarding traffic and the mitigation of that traffic. In our initial approval or allowance for our building, we looked at our assembly hall or sanctuary, which is a 2,500 seat capacity, and we have around 1,200 parking spaces. And we initially planned on 4 full services on Sunday, which would be around 10,000 people. So our traffic mitigation investment to the Stafford Orland roundabout was about $1.1 million, which was required of us, again, to mitigate that amount of traffic. The church was required to and did invest in building that roundabout that the county's then in effect capital improvement program acknowledged was planned for the area regardless of the church and would have never happened because it was so expensive without the church's investment. So we've mitigated for trips of about a 10,000 K congregation initially. There was also an additional traffic mitigation ODOT service road option off of Stafford Road, but that option was not approved, and there are no plans to use that service road for any reasons or connect it with the church moving forward. One of the things that has drastically changed from what we were initially approved for with regards to traffic is our attendance and building use. Our current attendance is far less than what was initially planned and mitigated for. Our Sunday attendance used to average around 5,000 members on Sunday and about 2,800 members at peak during the week. Currently, for the last 3 years, our Sunday total in-person attendance is around 1,100 people, which is a 78% decrease from what we originally planned and mitigated for. Our weekday average of people on campus during peak hours is now about 1,000 people, which is a 64% decrease. So that's going from about 560 daily trips to about 200 daily trips during the week. The proposed school would also replace ongoing scheduled weekly activities and gatherings that are now at the same time that the school would be, which would represent about 150 less people each day. So with the school of up to 150 plus 10 to 12 staff, the proposal is only adding about 10 to 12 people a day. And if students carpool, it will be even less than that. Because of the decrease in attendance and overall building use, this proposal actually represents a dramatically lower traffic profile and congregation than the church has already been mitigated for. Again, we have pursued this proposal based on our feedback from our congregation. Also, being presented proposals from other current schools that there's a need for this type of education. And that is extremely important to the church's religious mission and of educating its youth. And we feel that's a calling we need to step into. The county staff's professional analysis meets standards, and we respectfully ask for this analysis to be approved based off the proposal. I'll now turn it over to Ms. Killington.
Thank you, sir.
Hello, Wendy Killington, representing the applicant. Good morning to everyone. Thank you for being here. I
morning.
think before me, it's probably better to get the traffic folks in, and I noticed that they were made panelists. So if you would forgive me and let Jennifer Danziger and Mila Cross go first, I would appreciate it.
Of course.
Thank you.
Hello, can everybody hear me?
Yes.
Perfect. I'm Mila Cross. I'm with Lancaster Mobley. We prepared the transportation analysis letter. We scoped the TAL with Christian Snuffin to determine our scope of work. We did include trip generation estimates for 150 students. Those estimates do include all site trips, including all faculty and student trips.
Did we lose Mila? If we did, maybe Jennifer can jump in.
You're muted.
Okay, yeah, I'll jump in for Mila. I just got a text from her that says she's frozen. So, yeah, so she answered the question about the staff. So the trip generation rates are based on the number of students, but they include all trips to the site, so both student related and staff related trips. We did look at, we collected the data when public schools were in session, and there was a note about several schools in the area. 2 out of those 3 were in session. One actually started several weeks after the other schools, and so that is not included. But we did look at the trip generation for the site. The existing traffic that was out there when we measured it, plus our site trips, are actually still lower than the forecasts that were done for the 2009 update that was done for the site. So for the PM peak hour, that was the only hour that they had hourly traffic for, was the evening peak hour. They didn't have estimates for the morning, or in school's case, the afternoon as well. So we are lower than what was planned for the PM peak hour. The other thing that we did do was we did talk with Clackamas County. Mila was involved in that scoping, and I see she's trying to connect right now. So she might be able to provide a little bit more information about those discussions. But we did work with Christian Snuffin, the county traffic engineer, to talk about what was necessary. And their primary focus was whether or not the existing lane configuration on Borland Road at the site access was adequate to accommodate the school. And the other thing they were concerned about was making certain that any queuing for pickup and drop off could be accommodated on site. And so those are the focuses of the traffic study that we did. Mila, do you have anything to add?
Sorry, I just missed the first half of that.
Okay, I covered the staff, I covered the time, I covered the rates that were lower, but if you could add just anything that you had about scoping.
Yes, so basically we just had to look at on-site queuing, and the main issue that Christian wanted us to look at was if the left turn lane was adequate for the proposed use. And that should be it. I did send the email chain over to Wendy to submit with me and Christian.
And I did see it in the exhibits.
Okay, great. Thank you.
Thank you. I did have a question about, and it may not be pertinent, but just for my information or my I saw the proposed traffic for entering and exiting proposed for student pickup and drop off, and it appeared to be a figure 8. Is that how I was supposed to read that? It seemed a little strange. Traffic came in from Borland, entered the parking lot, and turned left, and went around the building and came out on the other side, crossing the entry traffic and leaving from the entrance. And I just thought was that intended, or um, was there any safety concern there?
The traffic does loop around the building and come back, and the exiting traffic would have to stop and yield to the entering traffic. So yes, there is a crossing point. That was the only way to do it, given the drop-off location for the school. So they went through the parking lot to make sure there's enough room as parents, because we all know parents arrive very early and queue up to pick up their kids. And so, yeah, it circles around the building, around the back side of the building, and then it comes into that T. So they would have to yield. But we don't expect that line to be moving very quickly. And these are also, parents who do this every single day. So the routine should get down pretty quickly.
I did note that it was quite a large parking lot area too.
Yes.
So, okay.
Mhm.
Thank you for answering my question. Ms. Kellington.
Sir, if I could just add to that as well, we have within the parking lot, we have,
Oh, Mr.
sorry,
Yeah,
this is
go ahead.
Mr. Houchet. We have the main entrance, which is 2 lanes in and out on each side. Then we have an accessory entry. And in the back, we have a half circle roundabout. And so many times, and we have the traffic bumps in the parking lot. So the speed is quite low. And there's multiple ways to go in and get to the roundabout that helps kind of mitigate the drop off in a safe way.
Thank you, sir. Ms. Kellington.
Yes, thank you. Good morning. There appear to be 4 issues that the opponents are concerned about. And my purpose in talking here today is to allay those concerns. First of all, there's a concern that the conditional use permits at issue have expired, and that is simply wrong. If I may share my screen, is that a thing I can do here?
I believe so.
Do I have the requisite permissions? Let's see. Okay. Can you see this email from Mike McAllister?
It is very tiny, but yes, let me see if we
Well,
can get any bigger on
all
this.
right, well, I will put it in the record, but it is an email dated August 5th, 2005. And what he's saying is, he says, Rolling Hills requested certificates of occupancy. This is for the big building. I have reviewed the approved conditional use permit files and design review files. All conditions in these files are met, except the condition in the recently approved minor modification file, which requires the church to bond or otherwise ensure the $1.5 million road improvement and any other conditions or requirements in the engineering SCE permit. Once those 2 conditions are met, let me know and I will sign off on the C of O for planning. I'm going to put this in the record, but one of the things I will also put in the record is the CFO that was signed off by planning and that was issued to the church for the large building. So there should not be any issue about any expiration here. And I don't even think we need the 2009 CUP to modify. I really think it's just enough to modify the 2002 one. But regardless, but as staff will tell you, both of those have had requisite important permits issued, especially 2002 is completely finished. And so there really isn't an expiration problem here.
I do want to talk about that briefly. So the conditional use permit that was approved, the use has continued uninterrupted.
Uninterrupted at all times.
That's it.
That's it. Yeah, thank you. And then this idea about a new conditional use permit as opposed to a modification being necessary, frankly, puzzles me. It feels a little bit like Dr. Seuss's butter side up or butter side down. It's still toast. And the fact is, we are getting a new permit. So the 2002 conditional use permit said, you know, if you're going to have a real school, you're going to need a new permit. Well, guess what? This will be a new permit. It will be called a modification permit. It is a new permit. And this idea that you can't modify a conditional use permit makes no sense to me, because that's what the code says. That's what 13 is all about, is modifying a conditional use permit. That whole argument just feels sort of, I don't know, make work, if you will. I mean, it's not even that, because I just can't find any merit to it, to the extent that there's something procedural there. I can't imagine how anybody's, you know, substantial rights were prejudiced. The CPO got notice, all of the agencies got notice, everybody got notice. So I just don't understand what that argument is about. But to the extent that there's some claim that's been raised that you can't modify a conditional use permit to add this parochial school, the code betrays that argument, and it's false. Third, there's this idea about traffic, and that, you know, the church, that there's already an awful lot of traffic in the area and the church needs to pay its fair share. And I think that requires a bit of a history lesson. This church has mitigated for a congregation of 10,000 people, and that's why it was required to initially build and then contribute to the build of the roundabout. It has made significant contributions to mitigate traffic for a much larger congregation than we are talking about here. And as the executive pastor of the church explained, right now there are a number of uses, Bible study uses, that happen in the classrooms that will otherwise be used as a part of the school, that happen 5 days a week, Monday through Friday, during the same periods of time that the school is in session. Those uses will discontinue during the period of time that school is in session. And if the hearings officer wanted to have a condition of approval to that effect to nail down that point, nobody objects to that. The fact is that represents about 150 people, plus or minus, every single day, who will not be in the building. And instead, the kids, 150 kids, up to 150 kids, will be in the building. So the traffic, in fact, is a wash. There's also a claim that we should be looking at daily trips, but of course, as the hearings officer is well aware, that the analytical operational bogey is the peak hour, and the peak hour trips that the school adds are nominal. There's no dispute in the record. There's no evidence in the record to undermine that the trips that would be added here, assuming that everything is continuing the way it does at the church, and this is a complete add, which it's not, as I've just explained, that they would still not have any adverse consequences to the area. But I think for purposes of the relevant approval standards, that there is no additional impact to public facilities or to traffic congestion, because the church is giving up a use that occurs during the same period of time and basically replacing it. And finally, there's a concern about the service road, which I really don't understand either. There's no proposal to use the service road. There's no way to link up to use the service road. The church doesn't want to use the service road. It was a subject of a lot of angst where Schwabe represented the church, Jill Jeleno, to persuade ODOT to allow the church to use the service road. And ODOT said absolutely not. And so, I mean, the service road just isn't a thing. There's no proposal to use it. Staff said they're not going to use it. I'm telling you, we're not going to use it. The pastor told me we're not going to use it. So I don't know where that concern comes from, but I assume that you will add a condition of approval to the extent you decide to approve the proposal that says that the church will not use the service road. So with all of that, I don't have anything else. of course, I'm available for question. I heard you say, Mr. Hearings Officer, that there's been a request to leave the record open. I understand that that's a request that you have to allow. And that's fine, but we would like to co-equally participate in that, and we would
Of course.
reserve the opportunity for a final written argument.
Of course. I do have a question. I believe I saw condition that there was use of the service road for emergency access. Was there fire access or something of that nature?
So our pastor prior to talk about that, I don't even know if we could get to it from the church.
Yeah,
So
There was an initial plan to create, connect the road from the church, and actually started in the process with platforms that were going over Athey Creek. And after the county NODOT said no, that process was stopped. So there is no connection between the service road and the church at this time.
Okay, I only
It's
saw a proposal
impassable.
then.
yeah,
What?
I
That's
only
the
saw a
proposal.
proposal to do that then. So it is not part of your fire access plan,
No.
part of your emergency access plan in any way. I
No.
think you have 3 different accesses points to the property already, correct?
Correct.
Okay, thank you.
So I don't have anything else unless you have other questions. Thank
No,
you.
that was it. Um, I'd like to provide an opportunity for Mr. Yamada, the appellant, or one of the appellants.
Hi, do I have to introduce myself or anything? Other than
Yes, please.
this, so my name's Randy Yamada, and I'm the Stafford Tualatin Valley Community Planning Organization chairperson. And we appealed it basically to because there was no application notification issued to us. So in being the CPO, we have Zoom monthly meetings where we let the community know what's going on. And without that, there's no ability for the community to respond to this land use action. And also other people that were aware of this and people that are commenting on this proposal have been involved in the community for decades. That is the Stafford CPO, the Stafford Hamlet, and other like Mr. Fellow and others who are probably in attendance off screen. They know the history of our urban reserve agreement that was and what was promised and how it was intended to impact limitations on interim development in Stafford. And this is a rural residential farm forest zone. So it is not an industrial zone, not a commercial zone, or not another type of zone. The church is, of course, is federally mandated, the church use, federally mandated, state and state protected right. However, the approval of the parochial school is a conditional use, of
That's
course,
correct.
but not a mandate.
Correct. As I understand it, you agree that the existence of the church, the use of the property as a church, that's a primary use of the property.
Right.
But you're correct. The school use of the property would be a conditional use requiring a conditional
the
use
church,
permit. And I am familiar
right,
with your CPO, the Stafford Tualatin CPO is very active. and attends quite a few hearings and provides meaningful input. And I commend you for your citizenship. It's important to have that type of input, and a person like myself needs that information. I don't live there, and I don't know all of the details of that. I did want to bring up, because I made a note that the notice was sent, emailed to the Stafford Tualatin Valley CPO on uh, May 7th, 2024. And it shows it in the notice information for that. Is there an issue with receiving the notices that are coming, that the
There
county
is.
sends? I want to make sure that just as you're interested in receiving them, I do want to make sure that you're appropriately receiving notices that are sent by the county, and have your system in place to process those, and have your members at your monthly meetings that you described have an opportunity to discuss them.
Thank you. So there is a problem with receiving this notice in particular, and a problem with receiving previous notices. And there also is a problem with, we'll receive a notice within a week of our actual meeting. And so we'll have to run around and try to make a decision in like an instant. So, and we did not receive the notice, but the primary issue is we did not receive the notice for this meeting. There are other situations, and I don't think we can resolve or go over that at this meeting. So
Some of the confusion may be that there wasn't actually a public hearing here, and if the expectation was a public hearing, then you're correct, there wasn't one.
that was not that has the issue is that we did not receive this notice.
Okay.
Sometimes we receive notices just a day or 2 days before the meeting, and so we don't have time to discuss like the final notice appears to, as the final notices are appearing just before our meeting, which is not appropriate. So
Do you have a designee within the county staff for communication of this nature? Yeah.
listen, we that's a separate issue.
Okay.
Okay, so we have a number of issues that we have to resolve for the county, but the real issue right now is that, yeah, we didn't receive the notice. So we couldn't be involved in this process, right? And we don't know if we could have had a broader impact on what these folks are deciding to do or not. And I think that's the case for many of the situations that we've been having with the county and coming up. So in the future. So in this particular instance, though, the issue that I have is that these folks who are commenting on this thing, a lot of them have been involved with the CPO, with the Safford Hamlet, for a very long time. They understand what was promised in the urban reserve and what is promised under this conditional use requirement. And like I said, this is a rural residential farm forest 5 zone. And it's not an industrial zone. It's not a commercial zone. The other thing is that this school could easily be located in one of the adjacent cities. So why, and that doesn't ever seem to have been discussed in any of these conversations. And the other thing is that, well, I'm wondering why there are photos of school activities currently in a modification of the application that was sent out later. And is there a current is there current school activities occurring at the church? Or was that or are those just general photos of school activities for some kind of representational purpose? And so I'm just wondering if you can let us know how you propose to allow an equitable period of public comment. And so the other thing is, on the request to leave the record open, I don't know, I don't think we knew enough to request that. So, but what I'm wondering is, for others who could comment if the record were left open, do they have to comment now in order to have the right to do that? Or can they, is it possible, if you leave this record, the record open, is it possible for others to comment in the future?
On this application, I will leave the record open after the conclusion of this hearing and any continued hearing in this matter for a minimum of a week for the submission of new evidence and materials, a minimum of a second week for rebuttal, and as Ms. Kellington mentioned, a minimum of an additional week, third week for the applicant to submit a final written statement in this matter. I'll discuss that before closing the records, but to answer your question directly, any member of the public could submit a written comment during that initial period, and I would review it and consider it.
Can you make that initial period longer than a week?
I will discuss it before closing the record.
Okay.
Okay.
Thank you very much.
Okay.
I've submitted other comments that were different than this. So
I did see.
I'd like you to
some in the
consider
record.
those also.
I
Thank you.
will.
Appreciate it.
And I wanted to make sure that I discussed an issue there that was perhaps the initial issue, which was you're receiving that notice at all. And I heard what you said, that the Stafford Tualatin CPO did not actually receive the notice, that even though the record here that I have shows it was issued May 7th.
It was not received.
So something needs to be.
Planning department admitted that it was not received.
And is that, Ms. Fields, what do you know what happened there?
When I checked the file, it appears that the notice was sent to the Far West CPO in error.
I apologize for that, Mr. Yamamoto.
As a type 2 land use decision, the notice period is 20 days. And the CPO did receive a notice of the decision. And with this hearing, there was a notice of 20 days prior to this hearing. So there has been notice sent to the CPO and since then.
I apologize for the mistake there, Mr. Yamada. For your CPO, you should have that notice and opportunity to provide comments before the decision is made. But I will absolutely consider your comments as if no decision was made prior to my decision. I will review every one of them.
Thank you.
Of course. And before I close the record in this matter, I will also make, as I stated at the outset, an opportunity for members of the general public, and that would include any members of your CPO who are present and want to make comments directly during this hearing. So they'll have an opportunity as well. Mr. Fallow, as the second appellant in this matter,
Just
I'd like to provide you the same opportunity to present evidence, testimony, and legal argument that you would like to make in opposition to this
this,
application.
will be speaking to that for me, but just one comment I'd like to make that goes along with Mr. Yamada is that as a type 2 process, with a modification, the area of notice is much more constrained than if it was a type 3. And a significant number of our Borland residents were not notified around there that are directly impacted by the traffic, et cetera. And it's a very short period of time. By the time we got the written notice, et cetera, to the 6/6 final notification for presenting any kind of comments, many people were not able to do that. And the other part was that there were significant changes to the original final plan that was presented up until in December, just a few weeks from the time the final decision was made, that none of us were able to communicate back because it significantly changed what originally was presented. So just wanted to make that comment that this type of a modification restricted our ability to communicate, not just ours, but our neighbors. And with that, I turned over to our attorney.
Yes, and I do understand. As I understand your concern there was a much smaller area for the issued notices. I think it's 500 feet, whereas if it were a type 3 application, it would have been about a half mile.
Yeah, but also there were final, then revised final, and then
Yes.
another final that changed things significantly, and information that was given. So anyway,
There
yes.
were a number of changes to the application and the scope, yes. Mr. Burgess.
Hello, thank you. Jesse Burgess with Schraube Williamson and Wyatt, representing Stafford Industries, or I'm sorry, Stafford Investments LP. To follow up on Robert's comments there, it's our position that the proposed school use requires a new CUP application. Respectfully, this is not make work. The accessory school use that the church engages in under the CUPs can't be bootstrapped as a simple modification from the prior approvals to under the current application here. This is supported not only by section 1309 of county ordinance, but also by the underlying CUPs that are purported to be modified. The 2002 version of Z35102 clearly stated that the school uses were limited to Sunday school uses, a summer Bible vacation, and it required that any expansion of the school use would require a separate permit. Likewise, the subsequent 2003 decision of 351 on reconsideration provided in its decision that any accessory uses shall not be operated independently from the operation of the church and shall remain incidental. The intensity of accessory uses shall not be greater than that described in the application. This should have prompted this to be kicked out of a type 2 modification under section 1309, which provides that a modification shall be consistent with the prior approval. This simply is inconsistent with that condition in 351 that accessory uses shall not be operated independently from the operation of the church and shall remain incidental to the church use. To get back to the last two comments regarding the differences between the type 2 and the type 3, there are the notice and hearing requirements that they mentioned, which I'll discuss in a moment. But there's also, I think, more fundamentally, the differences in the actual levels of review under Section 1307. Type 2 permits are administrative in nature, involve land use actions governed by standards and approval criteria that generally require the exercise of limited discretion, in contrast with type 3 permits, which are quasi-judicial nature, involve land use actions governed by standards and approval criteria that require the use of discretion and judgment. So it's not just make work, these are actually different things, and I think that everybody knows that. And that's why we're fighting over it here now. Under the notice and hearing requirements, as you noted, there's the 500-foot notice requirement versus the half-mile. There's also the CPO, special districts and government agency notice requirements. And then there's the, most importantly, the public hearing, which I think would have been fundamental to making a lot of people feel better about the process here. And I think, as everybody can acknowledge, process is important here. I think turning next to the issue of the expiration, we based our arguments on the expiration of the CUPs on the text of those two CUPs themselves. CUP 351 stated that its approval was valid for 2 years from the effective date. The following CUP.
Wait a minute. There are two issues here. So there is an application that needs, and so when a conditional use permit is approved, it's effective for the period as stated. And so how it generally would work would be that the applicant must implement the conditions and initiate the use, correct?
Correct.
Correct. So once the use though is an existing use on the property pursuant to the CUP, that use doesn't expire unless it's essentially abandoned, unless it's discontinued for a period.
Yes, I mean, that's true. I think that the waters are muddied here in that the church use is itself allowed outright under the code here, and that
The primary use.
and that the CUP here was certainly in the initial 2003 351 example, but to a degree, but I think much more explicitly in the 2009, essentially used primarily for the phasing of the build out of the church. But I think that I guess my point is to have the basis of the school use be a modification of phasing CUP applications that expired by their own terms is itself an indication that the type 2 modification process itself was insufficient for a standalone school use.
And sir, I do want to apologize again. I will go back and I'll
Sure.
review the memorandum in further detail. It was pretty lengthy and I didn't see it until this morning.
Sure.
So I did spend a good chunk of my morning with a cup of coffee and your memorandum, but I'll need to
Sure.
go over that in more detail.
Fair enough.
My question here, when it comes to that phasing, I'd just like you to state some clarification for me. Are you asserting that the approved initial phases were not implemented? That there was use?
No, I'm not asserting that.
Okay, I just want to clarify then. So my understanding is correct that there was an approved conditional use permit for some activity, that activity has been ongoing, and that is what the applicant seeks to modify here. Is that how are you addressing that part?
I'm sorry, can you say
I
that
am
again?
confused, and I just want to make sure I understand at least generally your argument. I'll review that memorandum and get into it too, but I want to make sure that I'm on the right track here.
Sure. I'm sorry. Could you state that last sentence again that you stated before the qualification? My apologies. I didn't
No,
quite
it's
hear you.
that there is no dispute that the initial approved CUPS activity, land use activity, was not discontinued, that it was.
Yes, I agree there. We don't argue that the use is discontinued or that there was necessarily a lapse. Our argument is that the CUPs were provided for the phasing of the build out of the church, that phasing has been completed, that's done.
So once a cup is approved, it doesn't actually expire. It can be discontinued or abandoned, which is the same as discontinued, but for a period of years, and then it can be considered no longer. I guess in that text, you might say, expired, but otherwise, I don't see the application here.
Fair enough. Understood.
Okay, go ahead.
Okay. I'm going to move on to the next part here. Moving on to the actual application of the Section 1309
Yes, sir.
criteria. I think as we previously noted, we think that the consistency of the modification with prior approvals under Section 1309-01A, as we previously noted, the change from a limited accessory use to a full-time school use is a significant increase in the intensity of the use of the property. And just because the church was built to an extent that its capacity intended for the church uses can coincidentally accommodate school uses during weekdays doesn't mean that there's no increased intensity of use or the impacts. As noted earlier in my comments, this causes, we think, the application to fail to satisfy Section 1309-01A with regard to the conditions of approval under Z0436-23. Additionally, the proposed school use will cause significant new impacts, we believe, in traffic congestion and on the use of public facilities on weekdays, in addition to the church use on weekends. We believe that this alone should have prompted the county to require a Type 3 CUP application because it causes the application to fail to satisfy Section 1309-01C5. I don't believe that in our letter, despite Ms. Kellington's characterization of the contrary, we made any comments about requiring mitigation. We believe that the traffic impact analysis itself failed to omit some relevant considerations that should have been included, including we think that it was insufficient for it to consider Borland Road as the only road in the vicinity of the church and to not include Stafford Road or the Stafford Road 205 interchange nearby. It didn't appear to consider the other schools nearby, or if it did, when it did the traffic counts, it appeared to have at least not done traffic count when one of the schools was in session. I'm a little unclear on that since it seems to have, one point it says that a traffic count was done on August 27, which was, I believe, before all schools were in session. And then it says another one-day traffic count was done on September 26th. I'm not sure which one-day traffic count was done. Not clear to me. Likewise, it stated that there was 2,500 existing parking spaces on site. As Mark Houchet noted, I think he said there was 1,200. We counted 1,000 from some Google Earth imaging. I think that there's a lot of inconsistencies in the traffic impact analysis, and it appeared from the decision that they just accepted wholesale the conclusion determination that the impacts of the church's proposal within the site vicinity are expected to be minimal. We think that that's insufficient. We also think that decision failed to address provisions of the county's transportation system plan. The property and nearby roads are outside the urban growth boundary and are considered rural roads. And we think that the application failed to address how it's going to be addressing the impact of the public facilities, including the aging roadways and enhancing safety and accommodating different modes of travel in the area caused by the proposed use. Again, we believe that the traffic impact analysis and the application are insufficient to meet the burdens under 1309 and should be required to be revised to explain how the proposed use would be consistent with the transportation system plan and how the traffic congestion and use of public facilities would be mitigated. Last comment I have regards the use of the ODOT service road. I know that this has been a long-standing issue. I think that it's a hot button topic for our client. I think that what we are looking for is some sort of condition of approval or some sort of carryover that the Z0436-23 finding and decision, which explicitly said that use of that service road would not be allowed, would be carried over into any approval or decision that's issued by for this proposed use.
If I were to approve the application, then I would certainly consider such a condition of approval as Ms. Kellington already, I think Ms. Kellington already suggested and approved that. And I heard the applicant as well, that there's no proposed use of that service road. And Mr. Fallow can be assured that that would be in any approval that I would issue. It makes sense to me as well. Did I answer your concern there?
Yes, I believe it does. And then, lastly, I think we've all touched on this a few times. We'd like the record to be left open. I think a 777 sort of arrangement would be, I think, good for us. If that would work for Ms. Kellington.
Well, I haven't quite gotten to that, but thank you, sir. Is that what you wanted me to consider before I provide someone else an opportunity?
Yes, please.
Perfect. And thank you, sir.
Yes, of course. Thank you very much.
At this time, I'd like to provide an opportunity for members of the general public to participate in this hearing, providing comments related to this application, either opposed or in support of the application. When you're called upon, and as it was earlier explained, use the raise hand feature if you wish to make a public comment at this hearing. And when you are called upon, please state your name and address, or you may state your involvement as well. Please.
I don't have any hands.
Okay. None. Let's talk about keeping the record open. I have a statement that I'm required to read prior to end or close of the record. Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument? All right, we know that there is a request to keep the record open. As I understand it, the request by the applicant's attorney, Mr. Burgess, that he provided in his written memorandum that I have received was for a minimum of 7 days. So now we have a request for a minimum of 7 days open record, during which any party may submit additional comments, including new evidence that was not introduced at the hearing in support of their position, or then a rebuttal period of 7 days will follow that, during which any any party may submit any rebuttal, but I want to ask that you keep the evidence related to your rebuttal. No new evidence, or no new topics that were not already introduced, please. And a final 7-day period for the applicant and Ms. Kellington to submit a final written statement. No new evidence in the written statement, either no new evidence in support of the application or in rebuttal. I'm looking for a legal argument or a final written statement. Any questions about what's intended here? Well, I will, at this time then, I will close the hearing, keeping the record open. Let's put some dates on this. 7/7/7. So I'm saying the initial period ends January 23rd at 4 p.m. So submit those additional statements to Ms. Fields at the county, and she will forward them to me and put them in the record, as she provided her email and contact information. Then we have January 30th at 4 p.m. for a rebuttal period, and that gets us to February 6th at 4 p.m. unless I have failed to appropriately calendar this. January 31st seems to me the last day of January. So did I get all the Mondays and Thursdays correct? Calendar. I have February 6th. Okay. Any questions before I close the hearing?
I do have a question for the applicant, whether they would be willing to extend the planning review clock to allow for this open record period to occur. Do you mind extending it for 30 days to facilitate the open record period?
No problem with that. I just was hoping that the final written argument, unless it's a big deal, could be on the 7th of February, one day later. I've got a really gnarly hearing on the 6th. And it'd be great not to have to submit something here until the 7th, the next day. If it's a big deal, then we'll just stick with the 6th and I'll make it so. But if we can extend the final written argument to the 7th, that'd make my life a lot easier.
Does anyone here have any comment about an extra day for Ms. Kellington? I don't either. Ms. Kellington, go ahead. I will make a note on mine that it is February, you asked till February 7th, correct?
Yes, thank you very much.
February 7th,
Appreciate
4
it.
p.m.
Thanks.
Okay, and what was your answer about extending the timeline?
Yes, no problem.
No problem. And so, Ms. Fields, I didn't look at that for the date, so thank you for catching that. I had assumed we had plenty of time, and I shouldn't assume anything. My mistake. All right, thank you for catching that. All right, well, thank you all for your participation. With that, I'll close the hearing, keeping the record open as discussed. Take care, everyone.